Thank you for joining us today. This is Jackie Clement, CEO and Executive Director of the Fair Media Council. Today, we welcome Carolyn Schurr Levin as our featured speaker for the workshop, Don't Get Sued, Common Website Mistakes. This workshop is part of a series of communication training workshops and is sponsored by St. Joseph's College. Thank you for your support. Carolyn Schurr Levin is a partner at the firm of Miller, Korzenik, Sommers, and Rayman, LLP, where she focuses on First Amendment, media, publishing, and intellectual property law. She has wide-ranging experience in pre-publication legal review of content and editorial risk management, and she currently teaches media ethics and law in the Department of Journalism and the writing professions at Baruch College. Before her full-time teaching career, Carolyn served as the Vice President and General Counsel of Ziff Davis Media and the Vice President and General Counsel of Newsday. Carolyn is a sought-after speaker, commentator, panelist, and trainer on First Amendment issues. She's also a member of the advisory board of the Fair Media Council. And I'd like to welcome Carolyn. Can you hear us okay?
Yes. Hi, everybody.
Okay, and we can hear you well. So what I'm going to do is I'm going to give you a screen so that people can see the outline of what you'll be presenting. Do you see that screen now?
I see it.
Okay, then it's all yours. Take it away.
Okay. Thank you so much for joining us today. We are going to talk about creating a website for your business or for your personal use, and making sure that your website fully complies with laws and regulations. We're going to discuss some of the issues to think about when you're creating a website. So this will be relevant whether it's a thought right now or whether you actually have a website. We're going to talk about some of the legal issues to take into account. Doing this upfront really saves you time and money and headaches later on. Because our time today is short, we aren't going to go into extensive detail about each of the issues that are on our outline that Jackie put up. But this is going to serve as a good introduction for you about what you should be thinking about and when you might want to consult with an attorney to discuss any issues that you have concerns about. So as a preliminary matter, before we get into our specific issues, it's important to know that many people don't believe that traditional legal principles apply to websites. They do. They absolutely do. So the rules and the laws that we're going to talk about this morning apply both in offline and in online environments. So we're going to limit our discussion to 10 legal considerations for your website. There's definitely more, but these are some of the most important things to think about as you create a website for yourself or your business. Okay, issue number one, content licenses. So this issue has to do with copyright. A lot of people think they understand what copyright is. Copyright is a term that is very misunderstood and often misused. So what copyright protects is original works of authorship that are fixed in a tangible medium. That's the language in the federal copyright law. This means that copyright protects written articles that you may post to your website, photographs, artwork, graphics, social media posts are all protected by copyright. So in creating a website, it is very important to know and feel confident that you have the right to use all the content that you are going to be posting. When you display content on your website, if you've created that content and it's your own original work, you don't need a license from anyone to post that content, obviously. But if you display content on your website that has been created by a third party, by somebody else, It is advisable for you to research who created it, whether it is publicly available, and whether you need to seek permission to post that content on your website. Often the owner of the copyright in that content may ask for specific credit or attribution. And this goes for copyrighted content, as I said, written content, photographs, artwork. In addition, many people use logos and names on their website. Logos, phrases, names are protected not by copyrights, but by trademarks. So if you are going to be using someone else's trademark on your website, you may also need a license from the owner of that trademark to display their trademark on your website. Often, if you're going to be using a third-party trademark, they may require you to put a disclaimer on your website that their company is not affiliated with you or does not endorse you or support you. So copyright and trademark licenses are important to know about. Even when you do obtain a license for content, the owner of that intellectual property may impose restrictions on how you can use it on your website. So it may be that you're not the only one that they're licensing that content to. So it's very important to understand what restrictions are imposed, what the terms of the license agreement are, what you're allowed to use the content for, and on what terms. It's very important to read and understand the license agreements. Second issue to be aware of, user-generated content. This refers to content that is created by users of your site. Obviously, user-generated content adds engagement and credibility to your website, but it can also open up certain legal risks for you. So the first question is, who owns the content that you're going to publish on your website? The second question is, what if that content is infringing someone's rights? What if it's defamatory? You don't want to be liable for content that your users are posting on your site. So there's definitely steps that you can take to reduce your risk as a website owner when you are posting user-generated content. The most important step you can take when you're asking users of your site to contribute to your site is to develop very, very clear terms and conditions for your website and make sure they are displayed prominently where visitors to your site can see them. Basically, terms and conditions are just rules for users of your site, and they will protect you and they will regulate your users' content on your website, including any content that they post. So users need to be aware of your legal requirements right up front. You should display them in a prominent place. They should absolutely make clear that illegal content, defamatory content is forbidden. And they should make clear that users are giving you the right to display the content that they're posting. So often people ask, why do we need terms and conditions on our site? Nobody reads them. They're too complicated. They're written in small print. That's a really good question. The reason that you need terms and conditions, even if nobody reads them, is that they are absolutely essential to protect you when an issue does arise. There are bots that scrape websites to make sure that there's no infringing content. And if you don't have strong policies in place, you could be liable for that infringing content. So you certainly don't want to open up your website to any kind of liability for infringing content that somebody else posts. Third issue, avoiding potential content claims. So I want to talk about a couple of different types of content claims. There are definitely others. The first claim that we want to minimize our risk for is libel. So libel is any kind of false statement of fact that could harm somebody's reputation, a living person, an existing company or organization. If you post content, whether it's a story, a press release, written content, a photograph, even a cartoon, that could potentially harm a living person's reputation, you could be exposing yourself, your company, to a potential libel claim. If you are posting that kind of content or hosting that kind of content, it is always a good idea to have that specific content reviewed by an attorney to minimize the risk of a libel suit. And an attorney who vets that content for you would give you ways in order to minimize the risk of a suit. In addition to potential libel claims, there are states that recognize legal rights to privacy. This is a tricky concept because it varies from state to state. So what may be an invasion of privacy in California may not be in New York. If you are posting private or personal content about people, again, that's the same type of content that you may want to consider having reviewed by an attorney to make sure that you minimize your risk of any type of privacy claim. Copyright claims we've already talked about. Third-party materials, not the original materials that you create, but third-party materials often, usually, require permission from the creator, the copyright owner. You should be especially vigilant about photographs and artwork, news articles, music, song lyrics, videos, social media posts. People think, oh, it was on Instagram, I can post on my website. Social media posts are copyrighted. And it's very important to ascertain whether permission is needed for third-party content. Last potential content claim that I wanted to talk about is breach of contract claims. Whenever you post or host content, you want to make sure that there are no contractual obligations that would limit your ability to post that content, such as employment agreements, such as confidentiality agreements, such as non-disclosure agreements, that you will not be in breach of any type of contract in posting content. Next issue, privacy policy. So we talked about terms and conditions and the importance of terms and conditions. One of the other most important legal requirements for your website is a privacy policy. All websites necessarily collect information from their visitors. This kind of information is often required for the functionality of a website. Sometimes people ask for users' experiences on websites. Sometimes they ask for email addresses. Sometimes you ask for credit card information from customers. So it is essential to outline for your users a plan of how you plan to use or not use any information that is collected from them. You should also inform all your visitors about how you're using cookies. Everyone knows what cookies are. They're small, tiny data files that are placed on a website user's device, and they're used for many, many purposes, including keeping users signed into a website, determining users' preferences, determining what web pages are being visited. So it's important to have a policy about how you are using cookies and to notify users that they can disable them, but maybe some features of your website will not work without them. But your website should specifically have a privacy policy that specifies what category of cookies you are using. Most websites use strictly necessary or functionality cookies to collect information. Some websites use advertising cookies. But you should know that there are places that require websites to delete user information at the user's request. So for example, there is a European privacy law, the General Data Protection Regulation, GDPR, that applies to any citizen of an EU country, irrespective of their physical location, that applies to websites that target EU consumers. There is also a California state privacy law that provides California residents with the ability to control how businesses process their personal information. It's important to understand that there are these laws out there, and they regulate and require how websites account to their users for data that is collected about them. They require websites to notify users that they can opt out of certain data collection procedures. So privacy policies are absolutely essential to protect you from any potential fines for violating these laws, and to protect your users as well, so that they know how you are using and tracking their personal information. In addition to a privacy policy, it is important to have a security policy for your website. Certainly a lapse of security can damage your entire website and your company and your business. And unfortunately, lapses in security are common, maybe increasingly common. So you want to create a strict security policy and a plan for what happens if there is a breach. This will give your users and your visitors confidence that their information is safe with you. I know many companies use WordPress, for an example, to create websites, and companies like WordPress offer security plugins that provide a basic baseline level of security that protects your site from being infected with malware and hacking attempts. So even basic security plugins can help you build up the security and the confidence in your site. Next issue to consider is whether your site has appropriate disclaimers. So a disclaimer is basically, a sentence or two that would limit the scope of your rights and obligations for the outcome of the use of your site. By including specific disclaimer language on your site, this may help protect you and may limit the types of claims that users can bring against you. So the disclaimer language can be used if a claim is ever filed against you to determine the extent of your liability for your website content. Disclaimers are different from your terms and conditions. The terms and conditions are basically the rules that govern the use of your site. But disclaimers are a little bit different in that they are essentially an attempt to limit your potential liability. Usually they're included in your website's terms and conditions, but there are often situations where you may want to put your disclaimers separately in a prominent place on your site. So for example, if your website is offering advice or instructional information to people, you may want to include a disclaimer right on your homepage that you're not making any kind of representation regarding the applicability of your advice to any specific person. So for example, WebMD has a disclaimer right on their homepage that WebMD does not provide medical advice, diagnosis, or treatment. This is a way to say we're offering medical information, but everyone's situation is different, and we're not saying that this will work for you. If you look at Glassdoor's website, they have a disclaimer, a basic disclaimer that they are assuming no responsibility for the content of any job posting on their site. So that if there is a problem with a posting or screener questions or resume information, they are basically disclaiming liability. So depending on what type of content you are hosting, A disclaimer can be crafted to protect you and limit your potential liability for that. Copyright notices. Unfortunately, you have to consider the possibility that someone may try to use your content from your website without your permission, whether it's text or photos or something else on your website. So to help deter infringers from that kind of content, a copyright notice should be put on your website whenever your site becomes available to the public. This is not legally mandatory, but it doesn't cost anything, and it can help deter potential infringers. So basically what a copyright notice is, it's just a written statement stating that my website is protected by copyright. You see them all the time. It says copyright with the C in the circle, 2021 with the name of your site. It basically puts the world on notice that you are claiming protection for your content. You can put it on your homepage, at the bottom of your homepage. I've seen it on every page of some websites. And basically it may stop a potential infringer from, may make them think twice before they take your content. It puts the world on notice. We're up to e-commerce rules, and I'm going to finish the outline, and then I'm happy to take any specific questions. So e-commerce rules will apply if your website includes any type of online transactions, e-commerce. If that is the case, then it's very important that you have a basic understanding of consumer protection laws and e-commerce regulations in the US. For example, you have to have specific content details that let customers know how to reach you. You need to have specific information about your prices, whether they include taxes. Your refund policy, your cancellation policies should be clearly visible at the point of purchase. And if you are engaging in online transactions, it's very important to have understandable e-commerce rules for your customers. Consistent information. We put this point on our outline because you're providing a lot of information on your website and also offline in company literature and promotional materials on your social media and stationery. Sometimes companies don't check all that information, and that the information that's posted on the website is different than the information that is in company literature. It's really important that everything is consistent. Your registered address, your office phone number, your email should not differ on your website than in all those other materials. For example, under the federal copyright laws, certain types of internet service providers are required to designate an agent to receive notifications of copyright infringement. That information, if you are required to have a copyright agent, should appear in your terms and conditions the same way that it appears in the Copyright Office registered agent directory. So consistency, it's easy to check and it's important. Last issue we wanted to talk about today is accessibility. It's not the least important, it's just the last of the issues we thought you should be aware of. The internet is designed to work for everyone, regardless of what kind of hardware they have, what kind of software they have, where they are, and their abilities. The United Nations Convention on the Rights of Persons with Disabilities recognizes that it is a basic human right to access information and communication technologies. So it is very important, legally and ethically, that your website be accessible to all people with a diverse range of hearing and sight and other abilities. Accessibility to everyone is very important for any kind of company that wants to create a high quality website and not exclude people from using their products and services. So if a website is poorly designed, it can create a barrier that will exclude people. So there's a lot of examples about accessibility, but here's just two I wanted to mention. So images on your website. Images should always include what you see referred to as alt text, equivalent alternative text in your code. If that is not provided for images, then the images are not accessible to people who cannot see, who are using a screen reader that reads aloud the information on a page. So when the equivalent alt text is provided, the information is available to people who may be blind, as well as to people who turn off images where places where there's low bandwidth or where the bandwidth is expensive. It's also available to technologies that can't see images, such as search engines. Another accessibility example of accessibility issue is keyboard input. Some people cannot use a mouse, including people with limited fine motor control, older people. So an accessible website does not rely on a mouse. It makes all functionality available from a keyboard. Then people with disabilities can use assistive technologies that mimic the keyboard, such as speech input. There are many other accessibility issues, but that's just an example of things that you should consider. So those are 10 of the many legal considerations you to be aware of when you're creating or updating your website. We wanted you to be aware of these issues to assist you in determining whether you're doing it right, or maybe when you want to consult with an attorney to help you update your policies or draft policies or look into any of these issues. A lot of legal issues can be identified and addressed early on, and people sometimes don't want to take the time to do that, but it will cut down on potential claims down the road. One final note before we get to questions, and this may be obvious, but I'm going to say it anyway. Merely knowing about these issues or merely consulting with an attorney with your website questions is definitely not enough. If you don't implement their suggestions, then the process of consulting with them is not going to be worthwhile. So it's very important to carefully evaluate the legal risks and the attorney suggestions and incorporate them into your website, or at a minimum, discuss why you don't want to incorporate them and why you think that you won't. So I am happy to take any questions that you may have on these or any other issues.
Okay, I actually do have some questions here. I'm hoping you touched on user-generated content. Let me give you a scenario though, and let me flesh that out just to make sure everyone's clear on this, because what we've seen in recent years is organizations and companies, brands, whatever you want to call them, using their websites as their own media outlets. So they're posting a lot of stories, but they also allow their readers to post comments. So are you saying that the website, if you allow the comments to appear on your website, that you are liable for those comments, or how does that work?
No, so that's a great question. What you want to do is make it clear in your terms and conditions that you are not liable for that content, but you want to let your users know that there are rules and that you need to post very, very clear rules that it is absolutely forbidden to post illegal or defamatory or infringing content on this site. So you don't want to encourage any kind of content that will potentially lead to a claim against you. And I think that your terms and conditions can really protect you against any kind of claims that you would be liable for.
Okay. And one other question here is, you are licensed to practice law in what states? We should probably make a disclaimer just in case someone's listening to this from somewhere
Good
else.
point. So all of these issues are important in whatever state you live in. I am licensed to practice in New York and Connecticut and DC, but and the laws do vary from state to state, as I said, with the privacy laws. The laws in New York differ from the laws in California. So it is important to consult with an attorney where your company is based to make sure that you comply with all the laws there. The copyright laws are federal and they apply throughout the country. So many of these different laws apply throughout the country depending on where you are. But it is important to consult with an attorney where your company is based.
Okay, all right, and that concludes the questions that I see. If anyone has a last minute question to pop in the Q&A box, please do. And otherwise, we'll wrap up. That was very informative and a great outline. Thank you, Carolyn.
Thank you,
All right.
everybody.
I'm not seeing any more questions, so we'll wrap up. Please, oh, wait, no, we do have a question. Hang on. Okay, here's a great question. Is there a specific type of lawyer we should consult? And are there resources for language?
So it depends on what you're looking for. I mean, there's definitely lawyers that specialize in e-commerce, for example, or in internet security. If you're looking for general issues about intellectual property, copyrights, then, you know, someone who specializes in media law. But it really depends if you're just starting out, if you want policies drafted, it really depends on what your concerns are. And what was the second part of that question, Jackie?
Are there resources for language? Part of this
Well,
is, are there
yeah.
templates online that people can
Yeah, there are
use, or-
definitely templates all over the place, and some of them are not drafted by lawyers. So I would be very, very cautious in lifting a disclaimer from the internet, you know, without consulting with an attorney about your specific business needs. You know, just lifting terms and conditions that may not be applicable to you is sort of not advisable.
Okay. Any other questions? All right, great. Then we're wrapping up. Thank you, Carolyn, for doing this for us today. Great advice as always. And we will be available online, fairmediacouncil.org, for upcoming events. So stay in touch. And if anyone has any questions, feel free to email me directly, Jackie@fairmediacouncil.org. Thank you so much. Have a great day.
Thank you.